Welcome and thank you for joining us for the Indigenous Treaty Law in the U.S. and Canada webinar, hosted by the Midwestern Legislative Conference Midwest Canada Relations Committee and the Great Lakes St. Lawrence Legislative Caucus. Before we get started, I'll review a couple of housekeeping notes. Today's webinar is being recorded, and a copy of that recording will be made available later this week on the CSG Midwest and GLLC websites. We will take questions for both speakers after both presentations have finished. You can ask a question by typing it into the Q&A feature throughout the presentations or by raising your hand during the Q&A portion to be unmuted. Those features can be found at the bottom of the screen, at the bottom of your screen. Myself and my colleague Jess will be moderating the Q&A, and questions from legislators will be given first priorities. But anyone can submit a question to be asked if time allows. Slide. As previously mentioned, this event is sponsored by the Midwest Canada Relations Committee alongside the Great Lakes St. Lawrence Legislative Caucus, also known as the GLLC. Wisconsin Senator Andre Jacques, chair of the GLLC, and Michigan Representative Amos O'Neill, chair of the Midwest Canada Relations Committee, are with us today to lead this session. We're grateful for their leadership and their partnership. At this point, I will turn things over to Senator Jacques.
Thank you, Mitch, and thank you all for joining us today for an important discussion. I am very pleased to welcome you alongside Representative O'Neill and introduce this topic and our speakers. The GLLC passed a resolution last January to enhance our partnerships with Indigenous leaders across the Great Lakes St. Lawrence River Basin. Part of this effort, guided through our Indigenous Engagement Committee, is to provide education to our members to better understand the context and history of relations between states, provinces, and Indigenous nations. We are joined today by two expert panelists to help us do just that. Professor Angelique EagleWoman is a law professor, legal scholar, Chief Justice on the Sisseton-Wahpeton Supreme Court, and has served as a pro tempore tribal judge in several other tribal court systems. As a practicing lawyer, one of the highlights of her career was to serve as general counsel for her own tribe, Sisseton-Wahpeton Oyate. She has taught in the areas of Aboriginal legal issues, Indigenous legal traditions, tribal nation economics and law, Native American law, Native American natural resources law, contracts, the business of law, and civil procedure. She presents and publishes on topics involving tribal-based economics, Indigenous sovereignty, international Indigenous principles, and the quality of life for Indigenous. She has received numerous awards in legal academia and has been a frequent speaker on issues of diversity, inclusion, and professionalism. At the University of Idaho College of Law, she established the Native American Law Emphasis Program and graduated students over 7 years. She also served as Dean of the Bora Faculty of Law at Lake University and was the first Indigenous Law Dean in Canada. She enjoys serving as a board member for the Minnesota Native American Bar Association. Currently, she is the director of the Native American Sovereignty Institute at the Mitchell Hamline School of Law in St. Paul, Minnesota. And at this point, I will hand it over to Representative O'Neill to introduce our second speaker.
Thank you, Senator. As co-chair of the Midwest Canada Relations Committee, I am pleased to introduce Professor Karen Drake. Karen Drake is an associate professor at Osgood Hall Law School at New York University and a member of Wabigoon Lake Ojibwe Nation, who researches and teaches in the areas of Canadian law as it affects Indigenous people. Anishinaabe constitutional Indigenous prodigy within the legal education, property law, and dispute resolution, including civil procedure and Indigenous dispute resolution. Professor Drake served as Osgood Associate Dean throughout the pandemic from July 2020 to June 2023. She joined the Osgood faculty in July 2017 from the Bora Alaskan facility of at the Lakehead University, where she's been a founding co-editor and chief of the Lakewood Law Journal. Prior to joining Lakehead, she articled the Castle Brock and Blackwell LLP, completed a clerkship with the Ontario Court of Appeals, served as part-time judicial law clerk with the federal court, and practiced with Erickson and Partners, focusing on legal issues impacting Indigenous people, human rights, and civil litigation. Professor Drake is a member of the Legal Advisory Panel for Raven and previously served as Commissioner of the Ontario Human Rights Commission, on the Board of Directors of the Indigenous Bar Association, and on the Board of Directors of the Human Rights Legal Support Center. Now I'll turn things over to Professor EagleWoman to begin her presentation.
Thank you very much. Thank you for that kind introduction. Amadakiapi Hihani Washte. Good morning, everyone. I'm going to be talking about treaty rights for U.S. tribal nations in the Great Lakes region. I am Professor Angelique EagleWoman. My name in my Dakota language is Wambadi Awanwichake Washtewiya, which means good eagle woman who takes care of the people. I am System Wapton Oyate, which is a Dakota people, part of the 7 Council Fires, Shakowee, Ocheti Shakowee. And I'm a professor at Mitchell Hamline School of Law, currently and director of the Native American Law and Sovereignty Institute. This is a picture of Leech Lake band members on Lake Superior. So the overview I'm going to be talking about, we have a long history of treaty making on Turtle Island. There was European religious doctrine that led to the formation of British treaty making and eventually US treaty making. Treaties are the basis of US tribal relations and are enshrined as the supreme law of the land in the US Constitution. Over time, the courts have developed treaty interpretation and what we call the Indian canons of construction for ambiguity in treaties. I'll talk about tribal reserve water rights, and we have a new EPA, U.S. Environmental Protection Agency regulation I'll be talking about. It came into effect in May 2024. I'll also be talking about litigation versus negotiation and how this is a full circle back to the promise of perpetual peace and friendship in treaties. So when we talk about the United States and we talk about tribal jurisdiction, we talk about 3 sovereigns in the United States: the federal government, state governments, and tribal nations. Currently, there are 574 federally recognized tribal nations in the United States. Almost half of those are Alaska Native Village tribal nations. There are over 300 tribal courts in operation. And U.S. case law, and we'll talk about this, recognizes that tribal nations reserve powers of self-government in the treaty-making process. Tribally enrolled people are dual citizens of their tribal nation and the U.S., and through U.S. citizenship have state citizenship. We often see interchangeable terms: Indian, American Indian, tribal, Indigenous, and Native American in this field. One of the reasons for that is because the United States government codified or brought into law the word Indian and American Indian. And I use the term Native American to represent American Indian and Alaska Native. So when we go back in time and we look at the beginning of the relationships with tribal nations, we do go back to Christian doctrine and law. There were orders by the Catholic Pope, and they're called papal bulls. And from these papal bulls, the doctrine of discovery was formed. The doctrine of discovery that affected this area of land was the bull Inter Caetera on May 4th, 1493. Pope Alexander VI issued the papal bull to Spain and said that all European Christians would respect the lands of other European Christians. But if you were non-Christian, often called pagans or infidels, then there was a superior title in Christians, and they had universal rights to monopolize trade and convert the non-Christians to Christianity. So this was the order that permitted settlement, colonization in what becomes known as North America and mid-North America. With British kings, they issued charters in the 1600s for trading companies and then eventually for colonies in North America under the language of the papal bulls. And the United States, in 1823 U.S. Supreme Court decision, Johnson versus McIntosh, traces its chain of title and relationship with tribal nations and says that when the Treaty of Paris was entered into with Great Britain, that the United States became a successor to all the rights of England, including the doctrine of discovery. Now, I ask, is this problematic? And often ask my law students that, is the United States a European-based government? No. So the papal bulls were for European-based governments. So there's a legal fiction embedded into the United States claiming the doctrine of discovery. I will say that there's been ongoing efforts for the Vatican to reject the doctrine of discovery, and that did happen March 2023, but the Vatican did not take any responsibility for anything that happened or occurred or any remedial actions due to the doctrine of discovery that was imposed on Native Americans and the indigenous peoples of these lands. The U.S. Supreme Court has not rejected the doctrine of discovery. It remains good law in the United States. And what it established in terms of property law is that a European nation stepping foot on soil gained superior title, and the tribal people only had what's called occupancy title, less than fee status on their own lands due to the doctrine of discovery. And so that's been used across all of mid-North America and Alaska by the United States. And so we have what's called Indian or Aboriginal title. And the United States Supreme Court has held that only where title has been recognized in federal law will that title be under the compensation of the Fifth Amendment's taking clause. So the U.S. Constitution, the Fifth Amendment says that if private property is taken by the U.S. government, then they must pay just compensation. And in a 1955 decision, Tehitan versus the United States, the U.S. Supreme Court held that only title that is recognized in federal law through a treaty, an executive order, or federal statute is actual title to be compensated. This gives you an idea of tribal nation commerce historically, so prior to the United States being formed. And you can see the Great Lakes are a huge hub of activity, as were a lot of the rivers across the United States. And there was trade going on from the tip of what we now call Canada to the tip of what we now call South America. And this is what first Britain and then the United States engaged in, as well as other countries as they came over. So a long history of alliances and treaty relationships. So when we talk about treaties from the tribal nation viewpoint, we're talking about there was a long history of alliances, confederacies, and what we would call treaties prior to British and French arrival. Tribal nations see these as sacred promises. Our oral histories contain the meaning of the treaties. And when the treaties were entered into, the tribal leadership said, we will extend this to all future generations, to our children, our grandchildren, our great-grandchildren. And this is from a kinship worldview, a worldview of we are taking you in as relatives and allowing you to set up permanent homelands within our homelands. Many tribal nations did not believe that they agreed to sell land to others. They could not be given land by newcomers. Some did agree to relocate to other lands, but many were coerced or forced. And our tribal nation leaders often had great foresight in reserving off-reservation hunting, fishing, harvesting, and ceremonial use. And these are perpetual rights. That means they never end, to go to the places where they always have had ceremony, hunting, fishing, all these different things, because they knew that by staying on the reserve lands, what we call reservations, they wouldn't be able to live properly. On the British and US side, these were seen treaties as expedient to acquire means for settlement and industry. They were written in the English language. They did use legal terms. Because of that, courts have adopted interpretive tools called the canons of construction. And the majority, almost every U.S. treaty promised perpetual peace and friendship, and that is the standard tribal nations are still enforcing today with the U.S. government and the state governments. Treaties were necessary for the U.S. to establish legal title to lands. Lands were seized where possible without entering into treaties, and that was, part of the recognized title and the just compensation decision in 1955. Almost every treaty has been partially or fully abrogated or violated over time without the U.S. return of lands, but usually the hunting and fishing rights or some part of the treaty still remains active, and that continues to uphold the purchase of lands under that. The U.S. Supreme Court has stated over generations that the U.S. Congress has plenary power over tribal affairs. Plenary power means absolute. Okay. The United States was formed with the American Revolution. The Iroquois Confederacy, also known as the Haudenosaunee Confederacy, had been living for decades with British representatives and with the colonies that are part of the American Revolution, and had entered into kinship relationships. 6 different tribes had different relationships, and they went with their kinship relations when this broke out, and so they were divided. With the formation of the United States, first there was the Articles of Confederation, and then the first treaty that's entered into by the United States is a treaty with the Delaware Nation, and it was sovereign to sovereign relationship and recognized the Delaware Nation as perpetual peace and friendship, relationship status, and even guaranteed the Delaware Nation representation in Congress. In 1787, before the ratification of the U.S. Constitution, under the Articles of Confederation, the Northwest Ordinance was passed. What this did in the Northwest was basically where the Great Lakes are at that period of time. It provided for a certain population of men to organize an area into districts as a territory and then petition for statehood to join the Union. So all this is happening as the Constitution is ratified in 1789. When we look at tribal relations in the U.S. Constitution, Article 1 and 2 granted the U.S. President with the Senate, granted the U.S. President and Congress authority to declare war and make treaties. So when we talk about treaty making in Article 1, the U.S. President then goes to a 2/3 vote of the Senate for the treaty to be ratified. We also have the Supremacy Clause, which I tell my students is my favorite part of the U.S. Constitution. And it states that the U.S. Constitution, federal laws, and treaties entered into by the United States are the supreme law of the land, and every state must abide by the supreme law of the land. We also have Article 1, Section 8, Clause 3, which gave Congress the sole authority to regulate commerce with foreign nations and among the several states and with the Indian tribes. And the original Article 1, Section 2, Clause 3 has a phrase, excluding Indians not taxed, which is a recognition that tribal nations and their members were separate entities with their own governance engaging in commerce with the United States. As treaties are interpreted, they are, like I said, partially upheld to justify settlement and ownership of U.S. claimed territory. And over time, there have been canons of treaty construction. So any ambiguity in a treaty must be decided in favor of the tribes. Treaties must be interpreted as tribes would have understood them, and treaties must be construed liberally in favor of tribes. So no hyper-technical legal interpretation. These interpretation principles are also applied to federal laws and federal regulations enacted for the benefit of Indians or tribes, and the whole Title 25 of the U.S. Code is dedicated to tribal nations. All right, the U.S. and each tribal nation are treaty partners, and that's the framework. So that's where we start. In 1871, the U.S. Congress suspended treaty making with tribes, but said that would not influence any treaty that had been previously entered into. So after 1871, we have executive orders from the U.S. President. We have the U.S. Congress passing law as agreements, and those have the same type of weight as treaties. State governments form a union within the federal government, and so again, the Supremacy Clause binds everyone within the U.S. government and the states to uphold treaties. I'm going to show you a quick time-lapse map here on land laws. And there's no sound with this video. All right, so that gives you a sense of the land laws and the reason for tribal nations to continue to negotiate to return often sacred lands that have been lost and other areas. This is a Bureau of Indian Affairs Midwest and Eastern Regions map, and the numbers here correlate to tribal leaders. So this is the Tribal Leaders Directory. So the Midwest region and the Eastern region involve tribes and the Great Lakes. There is a Great Lakes Indian Fish and Wildlife Commission. 11 tribal nations in Michigan, Minnesota, and Wisconsin are part of LIFWIC. This is an overview of 34 tribal nations of the Great Lakes Native American Research Center for Health, just to give you a sense of tribes. When we talk about water rights in the U.S., from the tribal perspective, we have Maniwi Choni, water is life. And that means there's a respectful relationship for this source of life. From the U.S. federal perspective, the legal basis is derived from the acknowledgement of territory, a treaty, a federal statute, executive order. We have U.S. versus Winans in 1905, which is a treaty fishing case, and says that any rights not granted by a tribe are retained. We have Winters versus United States in 1908, the reserved water rights for the purpose of the Indian reservation. So all reservations have a date of reserved water rights from the date the reservation is created. And then we have U.S. versus Adair in 1983, which is a Ninth Circuit case that said there also are water rights to support hunting and fishing rights as a purpose of a treaty. And then finally, U.S. versus Washington for habitat protection. When culverts stop the flow of salmon that are a treaty resource, Washington must remove them. So the reservation system, again, we have to have water rights that flow with the reservations. Otherwise, people would not stay on reservations. In the East, we have the riparian water system. In the West, it's prior appropriation. So the use of stream and shortages are shared. It must be of reasonable use and it's based on land ownership. Western is quantification decrees for prior appropriation. When we talk about tribal environmental regulation, the U.S. Supreme Court has not issued any decisions in this area. We do have the U.S. Supreme Court striking down Chevron deference to federal agencies in 2024 in Loper Bright. There are circuit court decisions that have upheld deference to the EPA on decisions regarding treatment in states for water quality standards by tribes. So between 1986 and 1990, the Clean Water Act, the Safe Drinking Water Act, and the Clean Air Act were all amended to include tribes' treatment as states, or tribes as states, TAS. The Clean Water Act has a national pollutant discharge elimination system and allows states to set water quality standards. We also have 33 U.S.C. Section 1377E that authorizes tribes to be treated as states and includes former Indian reservations in Oklahoma and Alaska Native villages. So the new regulation that just came out with the Clean Water Act is 40 CFR Section 131.9. May 2, protection of tribal reserve water rights. So a tribe who has reserve rights from a treaty submits that to the state or the EPA, and the state must, that's what the regulation said, take into consideration the tribal reserved right and take that into consideration when the state sets water quality standards. States and right holders may request EPA assistance, and the EPA will initiate the tribal consultation process. So again, this is new, and we're going to see this coming out, especially when we talk about energy pipelines and treaty resources and waters. So we know Michigan is in active litigation with Enbridge Line 5. There was just today a notification that the Bad River Band of Lake Superior, Chippewa are seeking to enjoin Wisconsin's approval of Line 5 that is surrounding their reservation. So we'll continue to see that. Litigation versus settlement, of course, negotiation is based on the treaty relationships of perpetual peace and friendship, more comprehensive solution. The Secretary of Interior has an Indian Water Rights Office, and 8 states are in relations with tribal nations in the Great Lakes region. And I will stop there.
Thank you so much, Professor EagleWoman. We will now turn things over to Professor Drake for her presentation.
Miigwech, thank you. Good morning, bonjour, anin kinagwea, papasekwe indigu, wabagoni, zagagan, and Anishinaabe, and Donjaba, Toronto, and Nongam. So I told you my name in Anishinaabemowin, and I'm a member of the Wabigoon Lake Ojibwe Nation. I didn't grow up there, though. I grew up in the town of Thunder Bay in northwestern Ontario. And now I live in Toronto, Ontario. I'm very grateful to be able to live here in the treaty lands and territory of the Mississaugas of the Credit First Nation. Thank you so much to the organizers of this event for this invitation to be here. And thank you to each of you for this opportunity to engage with you. I'm really looking forward to getting this chance to speak with you and to hearing your feedback, input, and questions. So my goal today is to explain some of the most recent developments within Canadian law on state obligations under Indigenous treaties. So to do that, I'm going to be speaking about the Supreme Court of Canada's recent decision in Restoule. In order to understand that decision, we're first going to have to understand something about Anishinaabe law, or in other words, the law of Anishinaabe peoples. I also want to give you a sense of where the law in this area might be headed going forward. So to do that, I'm going to talk about Canada's legislation on the UN Declaration on the Rights of Indigenous Peoples. And I also want to talk about a bill called the First Nations Clean Water Act that is currently a bill within Canada. Okay, now the first point I want to emphasize for you is that just like Professor EagleWoman mentioned with respect to the US, in Canada, treaties with Aboriginal peoples have constitutional protection. And this is by virtue of Section 35 of the Constitution Act. This gives constitutional protection to Aboriginal rights. Now, you'll notice I use the term Aboriginal, and that's because it's the term that's used here in Section 35. And so even though the term Indigenous is the more popular word in everyday language, Aboriginal is the correct term to use when we're discussing Section 35 because it's a legally defined term here. So you're going to see that I essentially use these two terms interchangeably. Okay, so given that Aboriginal rights and treaty rights have constitutional protection, meaning that all other law, including case law and legislation, must be consistent with treaty rights, right? So case law and legislation cannot conflict with treaty rights. So given this, it's vital to have a clear sense of what exactly these treaty rights are. To do this, we need to look at the principles of treaty interpretation. Now, the overarching principle of treaty interpretation that's been developed by the courts is the principle that we need to look for the common intention of the parties at the time when the treaty was signed. Now, in principle, this sounds completely reasonable, but in practice, it's extremely difficult to identify some intention that was held in common by the parties because, again, very similar to what we saw Professor EagleWoman speaking about, with respect to the intentions of the parties, in many cases, they are either entirely different, or perhaps even completely incommensurable. Okay, so what do I mean by that? Well, let's start with the intention of the British government as the predecessor to the Canadian government. Now, the intention here is reflected in the written text of the treaties. And if we focus on just the historical land surrender treaties, especially because these are common around the Great Lakes, we can see here that the intention of the government was to secure a surrender of the rights of Aboriginal peoples that exist within the common law. And so these are the very similar again to what Professor EagleWoman spoke about, the rights of occupancy that's left over after an incoming European nation asserts the doctrine of discovery. That's what treaties are meant to do from the British and Canadian perspective. Just extinguish those leftover rights that are left over after the doctrine of discovery. Okay, let's contrast this with an Indigenous perspective. Now, this is the perspective that's reflected in the oral agreements that were made on the ground when the parties were face to face engaging in negotiations with each other. Now, it's important not to overgeneralize, but we can get some sense of the intention of many and perhaps all Indigenous peoples in what's now known as Canada from the report of the Royal Commission on Aboriginal Peoples. So this is a report that was produced in 1996. And in order to produce it, the commission undertook 5 years of research and interviewed Indigenous peoples across the country. What they found is that Indigenous peoples consistently understand their treaties not as a surrender of their rights under common law, but instead they understand their treaties as entering into a relationship together and agreeing to share the land with newcomers. Now, we can actually understand this with a bit more specificity. And so the way I've explained it here is that it's an agreement to take care of each other as kin in a mutual aid relationship in accordance with Indigenous law. Okay, there's a lot there. What does all of that mean? Well, if we're going to have any hope of finding something in common between these different intentions, we need to understand Indigenous peoples' perspective and intentions on treaties with just as much sophistication and just as much nuance as we understand the government's intentions within the common law. So what I'm going to do now is spend a little bit of time talking about this Indigenous understanding, right, the Indigenous intention. What I'm going to do is focus on Anishinaabe law, or the word within the Anishinaabe language that's most often used for law is Anokinagawan. I'm going to do this to avoid a pan-Indigenous approach. I'm going to focus in on the Anishinaabe because that's my community. Wabigoon Lake Ojibwe Nation is an Anishinaabe community. Now, before I jump into this though, I want to clarify I'm not an elder and I'm not a knowledge keeper. And what I'm about to say to you here is not teachings, right? I'm not offering you teachings. You won't acquire knowledge of Anishinaabe and Okanagan just by listening to this brief talk. And I'm happy to say more about why that is during the question period if you have questions about it. Now, what I'm going to say here in speaking to you, I'm drawing from the work of Aaron Mills, and you can see the citation for his dissertation on the left-hand side. So Professor Mills is a member of Couchiching First Nation. He's assistant professor at McGill's Faculty of Law. I've learned through working with him, through engaging with his published works, and through sitting with him in courses that he's taught. He in turn has learned from his Nokomis, or grandmother, Bessie Mainville, and from other elders from the Treaty 3 and Treaty 1 areas. Now, I want to explain as well that what I'm about to say is not a definitive statement of Anishinaabe and Okanagan. Now, the reason I just gave you that account of the source of my knowledge, talking about learning from working with Aaron Mills and who he's learned from, is because there can be variations in how different Anishinaabe communities interpret and apply Anishinaabe and Okanagan. And so it's a common practice for us to acknowledge our sources so that you understand what communities my understanding is coming from. Now, I also want to acknowledge that with this very brief amount of time that we have here together today, it is impossible to give you the level of sophistication and nuance that I would like to be able to give you, but we have to at least try. Okay, so with those qualifications out of the way, let's start with the source of Anishinaabe and Oknagewan. The source, as I understand it, is not human institutions, the way it is within Western law, right? So Western law, we have legislatures, we have courts as the sources of law. Instead, the source is the natural world. Okay, what does that mean? Well, as I understand it, there's a normative order that inheres or exists throughout the natural world. In other words, inherent within the natural world are norms or values, and these norms then inform and give rise to laws. Okay, well now, what could that possibly look like? Well, the most foundational norm, as I understand it, that inheres within the natural world is the principle of Mina Gozawen. And what this principle says is that everything that we need to live a good life together is given to us as a gift from the natural world. And just as the natural world gives its gifts to us, we in turn have a responsibility to identify our gifts, develop them, so that we can give them away. And each of us has unique gifts. This includes our sacred gifts, but also just our ordinary gifts of knowledge, skill, labor, material goods, and so on. So we do this, we give away our gifts so that we can meet the needs of others within our community, just as the earth gives us its gifts to meet our needs. None of us has all of the gifts that we need to be self-sustaining. And so we're radically interdependent with other persons. Now it follows from this that the logic that we can use to think through and to solve legal issues is the logic of mutual aid, or the term that's sometimes used in the academic literature is reciprocity. Now, reciprocity here doesn't mean direct reciprocity. In other words, the logic of mutual aid is not the logic of contract, right? So reciprocity mutual aid does not mean a quid pro quo. So what I mean by that is if we have person A who gives away their gift, say to person B, B doesn't have to give a gift right back to A, right? So a gift doesn't require an immediate direct counter gift. Instead, B can give a gift to C, C can give to D, D can give to E, and so on. And as long as all members in a mutual aid society are giving their gifts freely in that way, eventually A's needs will be met as well. Now, there's another way in which the logic of mutual aid is not the logic of contract. And it's this: the terms of mutual aid, so what our responsibilities are under mutual aid, can't be decided up front for all time. The reason for this is because the key concepts within mutual aid are the concepts of gifts and needs, not rights and duties. Now, rights are expressed as generalizable rules that can be applied consistently to everyone. But in contrast, as I said, each of us has unique gifts and unique needs, and our gifts and needs change over time. And so we have a responsibility to continually renew our mutual aid relationships by considering what are our gifts now at this time, what are the needs of others in our relationships, how can we use our gifts to meet those needs. Now, this raises questions about the limits of our responsibilities, right? Whose needs should we prioritize? And if we have this responsibility to give away our gifts, does it mean that we have to sacrifice ourselves completely? No. The answer to those questions comes from our kinship relationships. So kinship relationships structure our mutual aid relationships differently. So for example, a relationship based on parents and children involves different responsibilities from, say, a relationship of siblings. Now, the reason why it's important to understand this is because a treaty is a mutual aid relationship within Anishinaabe and Oknagewan. It's structured in accordance with a kinship category. And just as mutual aid relationships need to be continually renewed, so do treaty relationships. And in fact, the British and the Anishinaabe did exactly this for almost 100 years. So from 1763, after the Treaty of Niagara, until 1854, the British and the Anishinaabe came together on a yearly basis, and they met annually at what's referred to as council fires, or in other words, meetings where they renewed their treaty relationship. Now, our relationship with the natural world is also a mutual aid relationship. It operates in just the same way. In other words, all aspects of creation are our kin. They give us gifts to meet our needs, and we have responsibilities to do the same for them. And this applies, as I said, to all aspects of the natural world, including water. Now, this is illustrated really nicely by the Nibe Declaration that was passed by Grand Council Treaty 3. So Grand Council Treaty 3 is the governing body of the Anishinaabe Nation in Treaty 3. My community, Wabigoon Lake Ojibwe Nation, is one Treaty 3 First Nation. So this is essentially Grand Council Treaty 3's law on water. So what it provides is that water is alive and has a spirit, and it can't be owned or controlled. And just paraphrasing some of the language in the Declaration, it also explains that all beings, including us as humans, have a responsibility to care for the well-being of water, and that water nourishes us and is a source of our well-being. In other words, we can understand those last 2 points as simply explaining a mutual aid relationship that we are in with water. Okay, so with all of this in mind, we can now engage with the Supreme Court's recent decision in Restoule. This was released just this past summer, and this is litigation that was initiated by the First Nation signatories to the Robinson Superior and Robinson Huron treaties. These are the treaties indicated in purple on the map. So they cover the northern area of Lake Superior and Lake Huron. They were signed in 1850. Okay, so what was happening in this litigation? Well, first we need to understand the written text. So the written text includes a surrender clause, as I mentioned, where the First Nations, according to the written words, were giving up their rights to the land under the treaty. It also contains a consideration clause. So in exchange for the surrender, the First Nations would receive an initial payment and then an annual payment going forward in perpetuity for all time. Now, there's also this really unique aspect of the Robinson Superior and Robinson Huron treaties, which is the augmentation clause. And it says that if the treaty would ever produce an amount that would enable the government to increase the annuity, then it would be augmented, provided the amount paid to each individual would not exceed £1, which was the equivalent to $4, or such further sum as Her Majesty may be graciously pleased to order. Okay, so according to the written text, this suggests that there is no legal obligation for the government to increase the amount after $4. So this language of may be graciously pleased to order involves discretion, right? It's completely discretionary for the government to decide whether it wants to increase it or not. And in fact, the government increased the amount to $4 in 1875 and then never increased it since then. Now, the First Nations signatories, though, were arguing that under Anishinaabe and Nakanagawan, a mutual aid relationship is very different from this absolute discretion, right? It requires that the government turn its mind to the gifts that it's able to offer. And no one disputed that the territory covered by these two treaties generate a massive amount of wealth that would have allowed the government to increase those annuities very greatly. Okay, so this decision reaffirms principles of treaty interpretation. So first, focus on the words of the treaty. However, the analysis doesn't end there. We also have to consider the historical and cultural backdrop. So it also affirms the 9 principles of treaty interpretation that Justice McLaughlin set out in the Marshall decision. Number 3 is the one I mentioned already, that this overarching principle of looking for the common intention of the parties. Next, the principles that are highlighted here are the ones that encourage us to go beyond just the written words, right? And that allows for bringing in that Anishinaabe and Nakanagawan. The 8th principle, though, is the one that says that even though there's going to be a generous interpretation, it can't exceed what's possible on the terms of the text. So it's a kind of counterbalance to the other principles. Okay, so what the court decided was that the obligation to increase the payment up to $4 was mandatory. After that, the further increases were discretionary. However, even though the government has discretion about whether to increase the payments, that discretion is justiciable and reviewable by the courts, right? So there is a legally enforceable element to it. And the Crown has to exercise its discretion diligently honorably, liberally, and justly. And all those principles are consistent with common law principles. However, the court goes on to say that when the Crown is exercising this discretion, it also has to do so based on values of respect, responsibility, reciprocity, and renewal, which are all consistent with that Anishinaabe that I mentioned. And that in this case, the Crown breached the Robinson treaties by failing to fulfill the augmentation clause, and the Crown is directed to engage in negotiations with the plaintiffs, and that the amount that it comes up with is going to be reviewable by the courts. And the part that I want to highlight here is this paragraph where the court says that these treaties are not merely transactional instruments, right? So not merely understandable under contract law. They're living agreements embodying a relationship that's been nurtured over many years before 1850. And they require ongoing renewal into the future. And the court exhorts the parties to return to the council fire. So here we see again all of these principles of Anishinaabe and Nakanagawan. So the outcome is that the Robinson Huron First Nations reached a settlement with the Ontario and Canadian governments for $10 billion. The Robinson Superior First Nations are still in the process of negotiations, and the government has 6 months from July, so that brings it to January of next year. So just over a month left in the negotiation process. Both sets of First Nations, though, still have to determine a process for going forward for implementing the augmentation clause. That $10 billion for the Robinson Huron First Nations, that was only for past claims. Okay, so just to wrap up very quickly, I wanted to mention the United Nations Declaration on the Rights of Indigenous Peoples because it contains provisions both with respect to protecting treaty rights and with respect to water. And in Canada, the Canadian government has passed legislation to implement the declaration. So Section 5 requires that the laws of Canada be consistent with the declaration, and Section 6 requires Canada to implement an action plan. Now, the action plan contains a section number 2, which affirms the responsibility to implement the historical treaties in accordance with principles of mutual respect, self-determination, and nation-to-nation relationship, and a reconvening of treaty councils. So again, we can see here bringing in those principles of Anishinaabe and Nakanagawan. Finally, I just wanted to mention Bill C-61. So this is merely a bill. It's not yet legislation, but it's very interesting because it would give First Nations the ability to pass their own legislation with respect to water over First Nations lands. And so here I provided a couple of sections that do just that, give First Nations the ability to pass legislation with respect to water. All right, with that, I'll end. Miigwech, thank you.
Thank you so much, Professor EagleWoman and Professor Drake, for that outstanding presentation. We are now going to open things up for questions. You can ask a question by using the Q&A box at the bottom of the screen, and you can also raise your hand and we will recognize you and allow you to ask your question. To start things off, I was wondering a question for both of you. What are the main comparisons between, the U.S. context and the Canadian context? Where are the big are there major differences in how treaties have been interpreted and enforced throughout the years?
That's a huge question. I'm going to say you've got two sort of perspectives. Courts in both countries have adopted interpretation guides, which we call canons of construction or interpretation. But one of the things I will say is the border between US and Canada was often called the medicine line because people who crossed it, the cavalry wouldn't cross it when they were chasing them. And so it's seen as a boundary, but we have relatives on both sides. And so the Dakota are on both sides. The Anishinaabe are on both sides. We also see Canada and the US as sibling governments coming from the same parent, Great Britain. So there are some similarities, but there is a trajectory of different things. One of the things that Canada has engaged in are modern treaties. And we see the United States halting the use of the word treaty in 1871. But we have a lot of the same, there are the same peoples involved in many cases.
I think what I can say, just in terms of the Canadian perspective, is that I think that our principles of treaty interpretation and what Professor EagleWoman talked about in terms of the canons of interpretation, to me, they look very similar on paper. However, the way that the Canadian courts have interpreted them up until Restoule is still very much focused on the written text. So there's all this language about a generous and liberal interpretation, all of this language about not simply using principles of contract. And yet that's what we saw the courts doing up until very recently. And that's why I wanted to spend a lot of time on the Restoule decision, because it really has opened things up to truly understand the treaties in a way that does give some effect to Indigenous people's understandings. Now, even though the augmentation clause in Restoule is specific to those two treaties, there are, I believe, 4 or 5 different other historical treaty nations who have initiated their own litigation since Restoule. So since that was decided just in July. And if I had to guess why, it's because they're not going to attempt to rely on the specific reasoning with respect to the augmentation clause, of course, because their treaties don't have that, but they're going to attempt to rely on those principles that are now starting to truly give effect to Indigenous law and Indigenous perspectives.
Thank you both for that. The next question is for Professor EagleWoman. Could you please share more about the relationship between the Winters Doctrine extension and what that means for this new EPA ruling for WQS? More specifically, how does the connection between water rights and hunting and fishing rights relate to a tribal nation's ability to influence the water standards in ceded territories? And what challenges and opportunities do you see for tribal nations in the Great Lakes region?
Great. So the Winters Doctrine is reserved water for the purpose of the reservation. That means for the tribal community to live. And with treaties, you also have reserved rights for water to live, but also in terms of hunting, fishing, gathering, and sacred sites. With water quality standards, like I mentioned, the EPA now has a regulation saying that the state water quality standards must incorporate tribal reserved rights. Before that, I also mentioned that tribes themselves can set water quality standards for their territory or reservation. Water is a unitary resource, meaning that if you set a water quality standard in the middle of the river, all the upstream users must abide by that standard. And we've seen that litigated in the 10th Circuit in Albuquerque versus Browner, where the 10th Circuit held the EPA had a reasonable interpretation that the inherent powers of a tribe allow it to set higher water quality standards than both the federal and the state. So what this can mean is that not only can the tribe set higher water quality standards for a river that goes into the state off the reservation or stream, but also now the state, when it's setting its water quality standards for that same water source, must take into consideration, is this treaty fishing? Are the deer drinking out of this as a treaty resource? So that's what we're going to see, I predict.
Thank you so much, Professor. And Representative O'Neill, did you have your hand raised?
Oh, I'm sorry.
Oh,
My mistake.
okay.
Thank you.
No problem. And the next question, how do you see these treaties being affected specifically by state law? In other words, what can state legislators do to preserve Indigenous rights and voices on a state governing level in the Great Lakes region?
So again, first of all, thank you for this opportunity to speak to you, and the fact that all states, almost all states have tribal-state relations. And that's a great place. And consultation protocols, that's a great place. What we see with the EPA and what we've seen throughout time over decades and hundreds of years with the United States government is more and more agreements are necessary between tribal and state governments because of their locality. They are very much connected. We have the same citizens. Tribal citizens are state citizens or US citizens. And so the perpetual peace and friendship, the negotiation, the ability to hear and understand why tribal nations want to protect a certain water source, all of those things are ways for state legislators to embody the historic and contemporary relationship. I always say we're permanent neighbors. The tribes aren't going anywhere. The state, the federal government's not going anywhere. It makes most sense for us to negotiate and work out quality of life across both territories.
Professor Drake, did you have anything from the provincial context?
Yeah, so from my perspective, seeing what's happening in Restoule, I would encourage government representatives to learn how to be kin, right? So what is the kinship relationship that applies with respect to whatever the relevant treaty is that you're working with? And which kin are you in that relationship? What responsibilities do you have in that kinship role? What are your gifts? What are the needs of the First Nations? How can you use your gifts to ensure that those needs are met? And this isn't, as I mentioned, based on a quid pro quo. It's based on truly having a sense of respect and responsibility and care for the other kin in your relationship.
Thank you. And then perhaps one final question. Both of you mentioned relatively recent changes related to Indigenous law in both countries. What are you expecting to see moving forward in the next couple of years, or is there a trend that you think we're observing in how the treaty interpretations are going and how the court cases are going?
So you're talking to two law professors. And we educate on the law, and particularly on the American Indigenous law, tribal law. And so I am going to continue to educate, and we're going to continue to see more lawyers who are trained in these fields and able to give voice to what the proper relationship is and what the standard should be. And I feel like our history has been very much suppressed in the United States, and that as each generation goes, we have more law professors, we have more lawyers, we have more people that understand the relationships, and more people in state and federal government.
And within Canada, the trend is definitely towards building, as I said, a truly sophisticated and nuanced understanding of the treaties within Indigenous law. So, as I mentioned in the past, despite the language of using a generous interpretation, we saw so much of the treaties being interpreted just with respect to the written text. And I think it's because judges and even lawyers just didn't know what Indigenous law was. Now in Canada, we have law schools across the country teaching Indigenous law in entire courses and also integrated throughout our curriculum. And so students that are graduating now, they do know. They can solve legal problems using the logic and those fundamental concepts from Indigenous law, right? So they're not just, these aren't just vague terms or concepts. Our students know how to work with them in a really fine-grained way. And that's going to be the expectation going forward. Our students are lawyers who are going to hold government to account to actually be able to work with treaties in accordance with Indigenous laws.
Oh, wonderful. I think ending things on a hopeful note for the future. Thank you both again. And at this point, I will turn things over to Senator Jacques to close out the session.
Thank you, Jess, and thank you again to Professor EagleWoman and Professor Drake for your presentations. And thank you to everyone who participated today. We'd like to invite you to register for the final webinar in the CSG Midwest series, which is going to be held this Thursday, December 19th, discussing technology and workforce development for rural regions. The recording of this webinar and registration for that webinar can both be found on the CSG Midwest website. And again, thank you all for joining us. Have a fantastic Tuesday.
Tadamayaye.